Welcome, everyone, to the Special Immigrant Juvenile Status Advocacy in State Courts webinar. Thank you for being part of this afternoon or this morning, depending on where you are. This webinar, presented by the ABA Working Group on Unaccompanied Minor Immigrants, will provide an overview of special immigrant juvenile status for attorneys, with an emphasis on the role of state court proceedings. I'm Christina Ritchie-Cooper of the ABA Center on Children and the Law. Today you'll be hearing from Meredith Linsky, Karen Grisey, and Christina Wilkes. Meredith is the director of the ABA Commission on Immigration. Prior to leading the commission, she was director of the South Texas Pro Bono Asylum Representation Project, or PROBAR, a national effort to provide pro bono legal services to immigrants and asylum seekers detained in South Texas. At PROBAR, Meredith represented individual clients and also trained for pro bono lawyers, law students, paralegals, and volunteers. Karen Grisey is Public Service Counsel in the Washington, D.C. office of Fried, Frank, Harris, Shriver, and Jacobson. Karen is also Special Advisor to the Commission on Immigration and a member of the ABA's Working Group on Unaccompanied Minor Immigrants and the Standing Committee on Pro Bono Public Service. Christina Wilkes is an immigration attorney with Grossman Law in Maryland and has extensive experience handling family and humanitarian-based immigration cases. Prior to her current position, Christina was the legal director of AYUDA, a nonprofit legal and social services organization here in D.C. At AYUDA, Christina also founded the organization's Children's Immigration Project. Now we'll turn things over to Meredith.
I want to give you a bit of background about the unaccompanied children's issue. I will be referring to it as the UAC, as UACs. I'm going to talk a little bit about the issue generally, the surge that happened last summer, ABA involvement, and the current needs related to legal representation. I'd like to begin with the basics. Who is an unaccompanied child? The statutory definition of a UAC is found at 6 U.S.C. Section 279G and includes someone who has no lawful immigration status in the United States, who has not attained 18 years of age, so under 18, and has no parent or legal guardian in the U.S., or no parent or legal guardian in the U.S. available to provide care and custody. Interestingly, this definition is made by Customs and Border Protection at the time of apprehension, usually along the border. This designation does not disappear when a child is reunified with a parent, because around 50% of these children are ultimately reunified with a parent, one or two parents in the United States. And so, although some of them will be going to live with parents in cities like Houston, Los Angeles, Miami, across the country, they still have the designation as originally determined at the border. So many of you, I'm sure, read about the surge last summer when unprecedented numbers of unaccompanied children and families with children entered the United States at the southwest border. DHS reported last year that over 68,000 unaccompanied children were processed by Customs and Border Protection between October 2013 and September 2014. That was a 77% increase over the previous year. And these children generally come from 4 countries: El Salvador, Guatemala, Honduras, and Mexico. Mexican children are treated differently than children from Central America, and we'll talk about that briefly later on in the webinar. The numbers have certainly come down over the last year. Between October 2014 and March 2015, a little bit over 15,000 children were processed at the border. That's a 45% decline from the previous year. But it still is double the number that had entered in 2011. So although the numbers are down significantly, they're still high, and there's still a very, very critical need for legal representation. The crisis that was at the border last summer has now transpired and transformed into a crisis in our immigration courts, and that's the reason that we're reaching out to you all now, because these children need representation both in immigration court and, in many instances, in the state court system. We're looking now at a map of Central America. You'll see that, and I'm sure you know, that children who are coming from Honduras and El Salvador are coming generally unaccompanied. This is the population we're focusing on today. Many times they are with some kind of smuggler, someone that's been paid by their family members, either family in the U.S. or back in the home country, and they often come in groups. They do need to pass through children from Honduras and El Salvador, Guatemala, and Mexico in order to reach the United States. And the truth is that the majority are entering in the Rio Grande Valley of South Texas, but over the last several months, there's been a significant increase in the number of deportations of Central American children from Mexico. And that is one of the reasons that the numbers have decreased at the border, not because conditions have improved at all in the countries, the original sending countries. We're going to talk a little bit about the causes of the influx. I think that one of the questions that was asked most frequently in 2014 is, what are the causes of this influx? There are certainly varied causes, and most of the people that have traveled to the United States come for multiple reasons. The push factors include violence from gangs, drug cartels, and domestic violence in the home, poverty, insecurity, impunity, and corruption, as well as the pull factors that include employment opportunities, education opportunities, and the opportunity to reunify with family members. Many of these children have been separated from their own parents for 2, 5, 10, even 12 years. They've been living with extended family members in the countries of origin, grandparents, aunts, and uncles, while their parents are working and sending money back home. And some of the kids even decide on their own that it's time for me to go be with my mother. I don't want to be here anymore. And then other instances, the parents send for the children. There's many, many reasons, but certainly the violence in Central America instigated by gangs and drug cartels is one of the primary reasons. Last fall, Jose Guadalupe Ruela shared some statistics about homeless children in Honduras. He's the director of Casa Alianza. And these statistics really do demonstrate the economic, political, and social factors that are causing the children to leave their country. Here he was talking about the fact that there are over 3 million children in Honduras, almost 4 million, and 1 million of them are not in school. 8,000 children sleep on the streets each night in two of the major cities, San Pedro Sula and Tegucigalpa. 25,000 have tried to leave Honduras in 2014 alone. 62% live in poverty. And the incidence of children being killed on the streets in Honduras has increased significantly between 2009 and 2014, from an average of 43 children a month to 88 children a month. I think this reflects the reality in all three Central American countries and demonstrates why so many children are trying to leave at this time. The issues as related to legal representation include the fact that the government does not recognize a right to counsel and removal proceedings, even for unaccompanied children, and few families have the resources to hire private attorneys. There are over 40,000 UAC cases currently pending in immigration court, with only about a third represented. In the past 18 months, almost 8,000 children have received in absentia removal orders because they did not show up at a hearing. They perhaps received faulty notice, perhaps didn't know how to get to court. Certainly representation serves to increase appearance rate significantly. It also has a significant impact on the outcomes. In a recent study out of Syracuse University, 73% of represented children were successful in removal proceedings, which means they were able to remain in the United States, while only 15% of unrepresented children were successful in their proceedings. The nonprofit organizations have been struggling mightily to respond to the need for representation, but there's always a larger need than can be satisfied. The immigration courts are inundated with cases. Specific judges have been identified to have juvenile dockets on weekly basis or biweekly basis, and these cases have been prioritized by the Executive Office for Immigration Review. So all this has caused basically a perfect storm in the immigration court system, and children are seeking representation in record numbers. Just quickly, I want to mention that most of the children that are part of the surge dockets came to the United States in late 2013, 2014, They were apprehended by Customs and Border Protection. They probably spent some time in a processing center, a Border Patrol center in Texas or Arizona. Children from contiguous countries, and basically we're talking about Mexico, are treated differently. They don't have the same rights to due process as children from Central America. They receive a screening from a Border Patrol officer. It's often a very quick screening, often not very thorough, and the majority of them, if they're not identified as particularly vulnerable or have an asylum claim, are swiftly returned through diplomatic means. Children from Central America, if they're determined to be unaccompanied, are sent to shelters along the border, sponsored by the Department of Health and Human Services, Office of Refugee Resettlement. And at those shelters, they receive services. They may have medical services, schooling, counselors, but the children don't remain in those shelters very long. Usually they're there from anywhere from 7 to 30 days, and the vast majority, perhaps 90%, are reunified with family members throughout the United States. Once a child is reunified, they'll have their first hearing in immigration court within 21 days, and this is one of the causes of the high in absentia order rate, because the cases are coming up very swiftly after the child is reunified. A child may seek an adjournment to find an attorney. As we mentioned previously, there's no government-appointed counsel in these cases. And the ACLU and some other organizations have filed a nationwide class action lawsuit challenging the government failure to provide representation in removal proceedings as a violation of due process. That's JEFM versus Holder. That case recently survived a motion to dismiss and is still pending. Some of the top states for UAC reunification include New York, Texas, California, Florida, Maryland, and Virginia, states that you would associate generally with high immigrant populations. Some of the top cities include New York City, Houston, Los Angeles, Baltimore, and Arlington. We've already covered the successful outcomes that children have with representation. According to a track study out of Syracuse University, only about 32% of the children are represented throughout the country in immigration court. That is an average. In some jurisdictions, the rate is higher, and in some it's lower. The ABA is extremely dedicated to this issue and has been working on this issue since last fall. ABA leadership, headed by past President Silkenat and current President Hubbard, took a border tour in July of 2014, visited shelters in San Antonio, Texas, and the Lackland Air Force Base. The ABA also attended a meeting at the White House where Vice President Biden urged pro bono legal assistance for children, calling together legal service providers, law firms, and advocacy organizations. In September of 2014, President Hubbard appointed the Working Group on Unaccompanied Minor Immigrants, where several different entities came together to work on these issues and develop and implement a response to the critical need for pro bono representation of children in removal proceedings. Last fall, the ABA led a survey of legal service providers to determine the major needs within the legal service provider community. And the greatest need identified at that time were volunteers to take with family law experience to represent children in special immigrant juvenile status cases. And this is where you come in. We have been reaching out to family law attorneys to try to get assistance with obtaining predicate orders in special immigrant juvenile status cases. I'm going to pass this over now to Karen Grisey, who will talk about this process generally.
Thank you, Meredith, and thank you, everybody, for your attention and participation here. The first point that I want to make, just to follow up on what Meredith said about these children coming into removal proceedings and then having the need for representation in family court. All of the children who are apprehended by CBP go into removal proceedings in immigration court. You saw that the cities where most of them are appearing in the immigration court, and you heard about the reunification with family members all over the United States. Reunification means that they get out of the shelter care system. They may be living with family member or a friend, but they are nevertheless still in removal proceedings, and they have to go to immigration court for a judge to determine whether they're going to get some relief from removal or they're going to be ordered removed. So the reunification is potentially temporary if they're not successful in getting relief from deportation. I want to point out at the outset that there are several different forms of relief that a juvenile may be able to obtain from the immigration court. Special immigrant juvenile status is only one of those forms of relief, but that's the one that we're going to be focusing on exclusively today. That's the one where members of the family bar, experienced practitioners in the state court, can be most helpful. So I just want to be clear that this is not the only remedy for these children, but it's the one that we're focusing on today. So what is special immigrant juvenile status? Why would a child want to apply for special immigrant juvenile status? It's a pathway to legal permanent residence, and legal permanent residence means green card, the right to live and ultimately work indefinitely in the United States, as long as there's no subsequent criminal history. And that's a remedy that's available to children who have been abused, abandoned, or neglected, and who obtain that status before they achieve the age of 21. That special immigrant juvenile status has been available since 1990, but some of the provisions were subsequently amended in 2008, so we're going to be talking in particular about some of those 2008 amendments today. Okay, so how would a child go about obtaining SIJS status, or if you're representing a child, what are the steps involved? First, it requires obtaining what's called predicate findings. Those are threshold findings from a state court. That a predicate order must be obtained from the state court before the child is able to go forward to obtain any immigration status. And I want to clarify here, because judges are sometimes confused by that. Even the state court who grants the necessary predicate order is not conferring any immigration status on the child and is not determining the child's right to stay permanently in the U.S. The converse, however, is true, that the child cannot proceed to get special immigrant juvenile status unless they have the necessary predicate findings from the state court. So once a predicate order is obtained, the second step is to file with SIJS a special immigrant juvenile visa petition. That's a paper application that we'll be describing in more detail further on in the webinar. And then the third step, if that special immigrant juvenile visa petition is approved, is the child then must separately apply for lawful permanent residence, and that can be done either before the immigration judge in immigration court, or if removal proceedings are terminated, before SIJS through the administrative process. Okay? So now we're going to go through an overview of eligibility for special immigrant juvenile status. The child must be unmarried, a non-citizen, under age 21, and must be under the jurisdiction of what's called in the statute a juvenile court, and the state court must have made the certain predicate findings that we're going to discuss in more detail. Who can these children be? They can be youth in removal proceedings, youth in state abuse or neglect proceedings, and these may be abuse or neglect proceedings in the United States, and also youth who have not, before the filing of this application, may not have been involved in the system at all. They may be children who have been in the United States under one circumstance or another, and some circumstances arise here that cause them to then fall into one of these eligibility categories. And we've bolded here the term unmarried. Sometimes there's confusion, but even if a child under 21 has one or more children themselves, they can still be eligible for special immigrant juvenile status as long as they are not legally married. All right, so what is under the jurisdiction of a state juvenile court? This means different things in one place or another, but the federal regulations cited here define a juvenile court as one that has jurisdiction to make judicial determinations about the care and custody of juveniles. I'll say here that sometimes the state court judges ask, why are you asking me to do something that has to do with immigration? And it's not that. It's that the immigration agencies recognize, and Congress recognized when it created the authorizing act, that immigration courts are not in the business of making decisions about the care and custody of children or the best interests of children. And so this statutory scheme was created to place those kind of determinations with the courts that are used to and experienced in making those determinations. And it's after that, then, that the federal agencies determine immigration status. But the juvenile court is one that has jurisdiction over the custody and care of juveniles. And you'll see here on this slide a list of various courts that may have this jurisdiction. In certain states, more than one of these type of courts may have the relevant jurisdiction, and in certain other states, this determination is relegated to one court in particular. So this is one of several areas that you'll hear about where it's very important for you to determine, if you accept a case, exactly which court in your local area has this jurisdiction. But it may be a traditional family domestic relations court. It may be a probate court. It may be whatever the court is that has jurisdiction over guardian, adoption, dependency proceedings. It may be a juvenile criminal court, such as a delinquency court, or any similar state court that has jurisdiction over determinations about care and custody of children. I want to point out here that the federal statute, as you saw in a previous slide, authorizes special immigrant juvenile status up until the age of 21, and that's true. But it's important to be aware that in some of the state courts, their jurisdiction over juveniles ends at age 18. So it's also very important to know whether your state's jurisdiction ends at 18, possibly 19, or maybe 21. But any type of application in the state court for special immigrant juvenile status has to be done soon enough to satisfy the jurisdictional requirements of the state court and still allow the processing of the special immigrant juvenile case by 21. All right, so we've talked about the predicate order that you must obtain from the state court. What are the necessary findings that the state court must make? The child has to be found to be either dependent on a juvenile court or legally committed to or placed under the custody of an agency of the state. These are kids that are in true foster care or shelter care at the state level. Or third, placed in the custody of an individual or entity appointed by a state or juvenile court. This is most typical for the children that we're talking about, where they are living in the care and custody of one parent or a member of their extended family or possibly a family friend. Second, the necessary predicate finding number 2 is that the child's reunification with one or both parents is not viable, and that the reason that the reunification with one or both parents is not possible is because of abuse, abandonment, or neglect, or some similar basis under state law. Here I want to point out that what constitutes abuse, abandonment, or neglect varies from one state to another under statute and under case law. There's no federal definition of abuse, abandonment, or neglect. So again, that's why local practitioners are really important to this effort, because they well understand what these terms mean under the state law. Also, There's a difference in whether the death of one parent is deemed to constitute abuse, abandonment, or neglect under state law, and that's particularly important because a lot of these children do have one or both parents who have already passed away. The requirement that one or both parents have to have abused, abandoned, or neglected the child is different since the 2008 amendments. It was previously that both parents had to have abused, abandoned, or neglected the child so that reunification wasn't viable with either parent. Some judges get confused about this because they remember the old scheme. That is no longer the case, and one-parent SIJ cases are definitely possible. The mistreatment by the parent may have occurred in the U.S. or in the home country. The parents don't ever have to have been in the U.S. for this to be possible. There's also some old language in the previous version of the TVPRA where there was a requirement that the child be found eligible for long-term foster care, and that is no longer the case. Okay, predicate finding number 3, and this is, the core of why state courts are best to make these determinations. The order must contain a finding that it's not in the child's best interest to return to the child or parent's previous country of nationality, or if there's no country of nationality, the country of last habitual residence. This is where the judge gets to consider traditional best interest factors. You'll see here the balance between the detriments if the child goes back. That is can consider health care, economic status, educational opportunities, who would care for the child, unrest, the gang situation, and so forth. All of those factors come into play on the risk or detriment to the child of going home, and that's to be weighed against the benefits and opportunities, security factors for the child staying in the U.S. Okay, so what is the federal immigration process? Now, you're going to hear from Christina after I'm finished how you actually go about obtaining the state court predicate order and the nuts and bolts of that. I just want to put for you that piece of the case in the context of the federal process. So we said at the beginning that the children who are in removal proceedings have to come back to immigration court after they get the state court order to actually pursue their immigration status. Here we just want to point out that it's not necessary that the child actually is in removal proceedings. The SIJS children that we're focusing on today almost always are, but there are children who have some way made it into the United States or been here for some period of time without being apprehended who are not in removal proceedings, and they are also eligible to pursue SIJS status. They aren't yet, however, before the immigration court, so their process is a little bit different. But let's assume that you have obtained the state court predicate order making the 3 findings that we just talked about. What's the next step? You first must file a special immigrant visa application with USCIS. That's called Form I-360. That's a self-petition for special immigrant juveniles. That means effectively the kid is on his or her own and is petitioning for his own status. There doesn't need to be a sponsoring or petitioning family member. Supporting documentation is required that proves who the child is, what's the nationality, what's the age. You do attach the predicate order with the necessary SIJ findings from the family court, photographs of the child, and there's no filing fee, so you don't have to be concerned about how you would pay for such an application. The biometrics process will come next. That's the child getting fingerprinted and having a background check, criminal history check. USCIS is obligated under statute to adjudicate this application within 180 days of filing. Usually they do that. There may be a request for evidence if you leave something out of your packet or USCIS has questions about some of the underlying documentation. There's a discrepancy in the date, or maybe the father isn't named on the birth certificate or some issue like that. You may get some request for additional information to which you respond, and then you'll typically get a decision on the papers. In some cases, there will be an interview at the local USCIS district office. Next, assuming you obtain approval of the Special Immigrant Juvenile Petition, the next is the application for permanent residence, which is the actual application for a green card. That's done on a Form I-485. This is basically to determine whether the child is admissible to the United States, and this may happen either at an interview before USCIS to determine the child's admissibility to the United States, or if the child has been and still is in removal proceedings, you can either do it there before the immigration court or get termination of the removal proceedings showing the approval of the I-360, and then you can apply for the permanent residence again before USCIS through an interview rather than a hearing. There are different reasons where you may make one decision or the other. Sometimes you're in the immigration court and you know you have a very favorable judge. Sometimes you can get a very quick hearing before the immigration court. On the other hand, sometimes you want to go before USCIS because the district office is closer to you, the court is further away or hard to get to, there may be big backlogs in your local court, you may not want to expose your child to cross-examination. There are a lot of different local calculations, but if the kid is in removal proceedings, you must terminate to do it before USCIS if that's your preference. If the child gets their adjustment of status application approved, that is, they've won their green card, they are a lawful permanent resident of the United States, and they can then apply for U.S. citizenship in 5 years. Timing, very briefly, the child has to remain under the jurisdiction of the juvenile court until such time as the application is approved. Pursuant to the 2008 amendments to the TVPRA, as long as they have filed before age 21, they will not be considered to have aged out while the application is pending, even if they actually do achieve the age of 21. So now I'm going to turn it over to Christina for a description of the state court process.
Thank you, Karen. So I have a difficult task here because I know that people are calling in from all over the country, and of course this is going to look different in different jurisdictions. Even here in the area where I practice, it's different in Maryland or DC or Virginia. So I'm going to do my best to provide helpful information that is sufficiently general to be applicable to everyone. The first thing I want to emphasize is how important it is to screen your case. Many of you may be taking on a pro bono case that you've gotten from a nonprofit organization or from the ABA. Or you may be getting a referral from maybe even an immigration attorney. And I can't stress enough how important it is for you to do your own screening and not just take it as a given that this is a proper SIJ case because it was referred to you by a nonprofit or an immigration attorney. I would say that my experience is that most immigration attorneys are really only kind of superficially familiar with SIJ, and so I'm getting lots of referrals for SIJ cases that really aren't SIJ cases. So, and I want to talk about why or why they might be problem cases and things to look out for. So one of the things that Karen talked about, and I'll get into this in a minute, but is that you need to have a basis for going into state court. There needs to be an independent basis in most scenarios, aside from just needing a special immigrant juvenile predicate order. For most of the surge kids that you'll probably be working with, most of them are probably living in the community with either one of their parents or with a family member or friend, Good Samaritan, what have you. And so in those scenarios, usually you're going to be looking at some sort of a custody or a guardianship or another type of family law action. So because of this, in some jurisdictions, if you have a case where one of the parents is deceased, you may have trouble getting into state court on a custody action, for example. In Maryland, for example, if one of the parents is deceased, then the other parent automatically has sole legal and physical custody, and there's no need for a custody action whatsoever. And in fact, most of the courts will just dismiss the action because the surviving parent already has sole legal and physical custody of the child. And similarly, sometimes you'll see cases where there's no parent listed on, there's like a mother listed on the birth certificate, and the mother is your plaintiff, but there's no defendant. There's no father listed on the birth certificate. And so this can also create a challenging situation is there an argument that the mother actually needs a court order granting her legal and physical custody? So some things to think about, especially in that second scenario, are maybe even though there is no father listed, maybe the father did recognize paternity in some other point in time, maybe as part of school enrollment or as part of some medical care treatment. Maybe he signed for a passport or an identification document. And maybe your court won't have an issue with it. But that doesn't mean that SIJS won't have an issue with it. And I'll get to that in a minute. We are seeing increased requests for additional evidence in these cases from USCIS. But anyway, so just something to be aware of and something to think about in the context of your state as to how you might get into court if you have a deceased parent or no parent on the birth certificate. Another thing to look at is whoever your plaintiff or your petitioner is, if it's not a parent, is this a good person to be having custody or guardianship of this child? Hopefully it is, but you definitely want to make sure. So sometimes you'll see a situation where not normally a parent, but maybe a family member or Good Samaritan who says, "Sure, I'm happy to take care of this child," but maybe isn't taking care of his or her own biological children. Maybe there's some children out of wedlock, not paying any child support, not supporting those kids. So that could be a potential issue for you. Maybe they have criminal convictions. And then I've also started to see problems with cases where it's really a potential parental kidnapping case. And you're, the kidnapper is the one sitting in your office. So the scenario that I'm talking about is, here's one that came in recently, was a mother who was a victim of domestic violence, mostly psychological and emotional abuse from her children's father. But she told me that the father was never abusive or neglectful to the children. He was a terrible husband, but in her words, a good father. She decided she had to get away from him, and so she left the country with the children, didn't tell him, didn't advise him, and the father has no idea where the children are. And so what are my grounds for saying that he has abandoned or neglected his children if she took them out of the country without his knowledge or consent? And up until then, he had been living with them and providing for their daily needs. So that's another thing to be aware of. And then another thing is who abused the child or who neglected the child. So sometimes we're seeing fact patterns where maybe the child did experience really terrible child abuse, but it wasn't by the parents. It was, maybe mom and dad had come to the United States and it was grandma or an aunt or an uncle was taking care of the child, and that's where the child suffered abuse. So in that scenario, is it possible to say that reunification with, one or both of the parents isn't viable because of neglect? So yes, there's a terrible history of abuse, but it wasn't by a parent. And then the other thing to think about is, and I'm going to talk about this a little bit more, but is what is truly in the best interest of the child. And I think this is an area where we're starting to see, well, not even starting, but there's existing, I think, tension between child welfare advocates and the immigration bar. In that I think often the immigration bar thinks that, of course, it's in the child's best interest to be in the United States and not to be in his or her home country, without any real consideration of, is that the case? And really thinking through, well, what are the pros and cons? And are there certain scenarios where it might be in the child's best interest to go home? And so I think that's something that I think with most of the Central American cases, we know that most of the children are fleeing violence, but it's not always the case. And of course, not all of the children that you might come in contact with are from Central America or places that have rampant violence. So that's another thing to keep in mind. So, like I mentioned, and I think Karen mentioned, is that you're going to need to file, some sort of action in state court. It might be custody, filed by a parent, seeking sole legal and physical custody, with the other parent being the defendant. It might be a third-party custody, where, it's a non-parent seeking custody. It might be a guardianship action, which, depending on where you are, it might be in family court, it might be in probate court. It might be some other type of family law action, maybe a divorce proceeding, where one parent has also sought custody. It might be, I understand, not in any jurisdiction in my neck of the woods, but I understand that in some jurisdictions it is possible to file for a declaratory judgment and obtain an SIJ predicate order that way. And then, of course, if a child is already in dependency proceedings because he or she's been removed from the home and is in foster care or has a pending delinquency proceeding, those cases really are much easier from the perspective of the attorney, because then you're really just working with the child welfare system, counsel for the child welfare agency, or guardian ad litem or social worker to obtain a predicate order in the context of already ongoing proceedings. But I think most of you are going to be looking at custody or guardianship actions. So I think the things you need to look at, and I think Karen mentioned this previously, but the next slide is kind of what is the standard in your state. So you need to look at the state definition of what is a fit and proper custodian or guardian. And again, are there any adverse factors in your case that might make your client less than ideal? And then what is the standard for abuse? What is the standard for abandonment? What is the standard for neglect? And is your court going to apply the standard of your state? Like what is, for example, what is abuse or what is neglect? And I think neglect is where this can be a little bit more prickly in Tennessee. Or is it what is neglect in Honduras? And is there any published decision in your jurisdiction about whether the state court should look to, neglect under your law or neglect under the country of origin? And I think one of the things reasons why this comes up is, in the United States, children are supposed to be in school up until the age of 18, and most jurisdictions say that if a child isn't going to school, then that is one grounds to find that there's been neglect. In many Central American countries, children often leave school well before then and begin working part-time, full-time, what have you, helping out on, family farms, things of that nature, in order to help provide income for the household. So is the fact that the child stopped going to school and began working, at the age of 12 or 13, is that neglect? Maybe it's not, because your state is looking at, well, what is